Confused about U.S. immigration? Or unsure which path is right for you? At Raju Law, we guide individuals, families, and businesses through complex U.S. immigration matters with clarity and confidence. Led by attorney Raju Mahajan, our experienced immigration attorneys share practical insights, real solutions, and up-to-date guidance you can rely on. Join our free online session every Monday at 11 a.m. Eastern Standard Time, where our attorneys discuss key immigration topics and answer your questions live.
Hello everyone and warm welcome to Rajula's Monday Live. I am Ms. Faraldushari Turing and I will be your host for this session. Today's topic is especially important for researchers, founders, artists, academics, and professionals aiming for the highest level of US immigration classification, EB-1A overview and recent case implications. A quick heads up for all the viewers, we'll be sharing our weekly immigration news updates at the end of the session. So be sure to stay with us till the very end. To guide us through today's discussion, we are joined by two special guests, Chelsea Smith, Supervising Attorney at Raju Law, and Alexandria Jordan, Associate Attorney and Team Lead at Raju Law. Miss Chelsea and Alexandria, it's a wonderful to have you with us. How are you doing?
We're doing great. How are you doing?
I'm doing great.
Thank you. I'm doing great too. That's great to hear. Our audience is excited to learn more about the EB-1A category, how USCIS evaluates extraordinary ability, and how recent judicial decision may shape future adjudications. Please go ahead.
Great. All right. Give me one moment to share the slides. All right, let's get started. So welcome everyone. I'm Alex Jordan. I'm an associate attorney here at Raju Law. And today I want to talk about EB-1A and a recent EB-1A case that has the potential to change how USCIS reviews similar cases. So let's go on to the next slide. So first, what is EB-1A? EB-1A is an employment-based first preference U.S. immigrant visa category for individuals with extraordinary ability. The EB-1A extraordinary ability category allows individuals who are performing at the very top of their field to apply for a U.S. green card without needing a job offer or employer sponsorship. To qualify, an applicant must demonstrate that they have extraordinary ability. Having extraordinary ability means that you have a level of expertise indicating that you are an individual at the top percentage of your field. This means you must show sustained national or international acclaim and recognition in your fields of sciences, art, education, business, or athletics. So when USCIS reviews EB-1A, oftentimes they're weighing whether you meet at least 3 of the 10 regulatory criteria laid out in the regulations. Or alternatively, you can have a one-time major internationally recognized award like a Nobel Prize, which can qualify you on its own, but oftentimes you're going to be evaluated under the 10 criteria. And as I briefly mentioned, EB-1A has some unique advantages. For example, you can self-petition. It doesn't require an employer sponsorship or perm labor certification. And also EB-1A sometimes has faster processing times than other green card categories. So here, briefly listed are the EB-1A criteria. You'll see there are 10 of them. You only need to meet 3 of the 10 criteria. However, the more criteria you meet, the stronger your case will be. Each of these indicates that you are showing extraordinary ability based off of the evidence listed. So just to run through them real quick, there are awards, which can include nationally or internationally recognized prizes for excellence in your field, memberships. Memberships must be in associations that require outstanding achievements, not simply paying dues to be a part of the membership. Published material, this can be articles or media coverage about you and your work in the field, and you'll want to see these in major publications if possible. Another type of evidence is evidence of judging. This includes serving as a judge of the work of others, such as peer reviewing, panel judging, or evaluating competitions. And you want to qualify for this judge role based off of your excellence in the field. Next, this is where we'll see the bulk of evidence is your significant original contributions to the field. This is one of the strongest criteria, and essentially it's evidence that your work has made a meaningful impact to the field. The sixth criteria is authorship. This includes scholarly articles in professional journals or other major media. 7, display of artistic work. This applies a lot more to the artistic fields. So here we'll want to see that your art has been showcased in exhibitions or shows. 8, a leading or critical role. This is evidence of leadership, that you've been essential to an organization or a project enough to make a very meaningful difference in the outcome. The 9th criteria is a high salary. Here we'd be weighing your salary or other remuneration for your services. So this can be bonuses, money to move you to location, different types of compensation. What we want to see is that this is higher than others in the field, which indicates success. And lastly, commercial success. Those typically in the arts, you'll see this through box office sales, record sales, or, any financial indicators of success commercially. Again, it's not just checking 3 of these 10 boxes. We want to demonstrate that you are of extraordinary ability in your field, and these are just avenues to demonstrate that. So now that we've covered the basics of EB-1A, what I want to do is I want to shift focus to a recent case that was determined in late January of this year. The case is called Anhita Mukherjee v. Lauren K. Miller. This is a district court case that recently influenced EB-1A, particularly how immigration officers evaluate evidence presented in an EB-1A case. Essentially, the court found the framework USCIS used to evaluate petitioners was not lawfully created. So before we dive deep into the implications of this case, it's important to understand the context. So Anhita Mukherjee was an accomplished Indian journalist, and she filed an EB-1A petition that ended up receiving a denial. USCIS denied her case based off of a 2-step review. First, they evaluated her under the 10 criteria, and they found she met 5 of the 10 criteria, which is nearly double the required 3. This established she met the specific evidentiary criteria. Then the second part of this process, USCIS applied a final merits test. Under this final merits test, the reviewing officer claimed that her most notable achievements were too old. These achievements had been accomplished before 2016, and they stated she had not proved she had sustained a claim. So essentially what they wanted to see was that she was producing notable achievements from 2016 all the way up to the time she applied for EB-1A. So when USCIS denied her petition based off of this final merits test, she disputed it. She argued that USCIS applied an unlawful and overly subjective standard at the final merit stage, and the standard applied was not established through formal rulemaking. This left the legal question of whether USCIS's final merits test used to deny the EB-1A petitions, even after you meet at least 3 of the 10 criteria, is valid under the Immigration and Nationality Act and the Administrative Procedure Act. As a result, the court produced 3 major conclusions. So first, the first conclusion found USCIS relied on a discretionary framework that was never formally codified through notice and rulemaking. This risked the framework being arbitrary and inconsistent with the statutory intent. So in other words, USCIS imposed extra subjective requirements beyond what the regulations required. Second, the court found that USCIS's decision-making process may have violated the APA, the Administrative Procedure Act. The court criticized several aspects of this final merits test, including the application of the final merits determination was an internal policy that was not grounded in regulations. It found that the application of this final merits test used unclear and legally inconsistent standards. And lastly, the denial of the I-40 under this test did not provide sufficient justification of why the evidence failed under law. And this is even when USCIS's own policy manual required officers to state specific and legal reasons for a denial. So as a result, the final merits test was not supported under the APA. And lastly, the court determined that USCIS used subjective judgment over objective regulatory evidence, especially where the petitioner had already satisfied multiple of the 10 criteria, which they found to be an overreach in judgment. So the final result from this case was the court rejected USCIS's denial reasoning, and they found for Mukherjee. The subjective and unclear determination without sufficient reasoning was too much of an overreach of power. So the court ordered the reconsideration or approval of the EB-1A petition, which left the door open for others to question the validity of the final merits test as a tool used for EB-1A denials. So why is this significant? First, it establishes that USCIS can be limited in its discretionary final merits test. Second, it strengthens the arguments for EB-1A approval based off of meeting the list of the 10 criteria. Third, it opens the door for challenges to vague denials. This means that cases denied due to the final merits test are more likely to have success challenging a denial in the future if there's not specific reasons for the denial listed. This case has set forth some strategic information that petitioners and practitioners can use when submitting their cases. So what we'll likely see and we'll strategize moving forward is aligning evidence directly with the 10 listed criteria. This is something most people already do, but the weight that's not given to the discretionary test because it's found to be overreaching is now shifted to this objective list of criteria, allowing the facts to speak for themselves a lot more. Second, preparation to challenge subjective adjudications. A lot of practitioners can use this case now as a tool for pushing back on USCIS. And this also transitions into formulating legal arguments against broad denials. What we'll likely see moving forward is this case used for arguments in preparing for these discretionary test applications, and a lot more pushing back on what agencies are using in their review and making sure it's objective, that it's applied fairly, and that the denials and standards are clearly listed. So even with all of these benefits of the case, there are some limitations. Because this is a U.S. District Court case, it currently does not have nationwide implications. USCIS would have to appeal the decision for it to reach a higher court, and this can result in either a firmer precedent being established or potentially the case being overturned. What we're more likely to see is that USCIS will revise its framework by establishing a formal test that aligns with the APA rulemaking. And this revised framework could address the court's reasons for finding the test improper. But as of now, we don't know which direction USCIS will take. So definitely keep your eye out for news regarding this case. It is very important for EB-1A and immigration applications generally. So to kind of wrap things up, the overall significance shows that courts are more willing to find that agencies applying arbitrary and capricious or unclear rules or improperly established standards of review are overreaching in their power. This case supports the importance of setting forth precise evidence and sticking very closely with the legal arguments and frameworks established through laws and regulations, rather than the informal policies of the agencies. Most importantly, this case places petitioners in a stronger position when they face vague denials based off of that final merits test. So we can expect to see some more challenges in the field as this case progresses and more information is released. So if you have questions regarding EB-1A, whether it's right for you or what this case could mean for your EB-1A petition, feel free to visit our website and reach out to us. We do have consultations and different evaluation forms to see whether this is the right fit.
And the only other thing that I would add to this is just a reminder that the rules for the EB-1A have not changed. This case is talking about that final merits process that the USCIS does to evaluate after evaluating those objective 10 factors to see if you align. So just for clarification, this does not negate the need for solid evidence for an EB-1A petition. If anything, what Alex is presenting to us, it shows that those objective standards are even more important in a time when the USCIS is receiving pushback for using arbitrary and capricious judgment of this final merits evaluation. So very interesting case. It's very significant potentially for what we could expect from the USCIS moving forward. We're all very interested in this and believe that based on what we're seeing with EB-1As, it's a really, if you meet the criteria, it's a really great time for the EB-1A applicants. They're seeing much better approval ratings overall from the USCIS right now. So what we're seeing is this federal focus on extraordinary ability right now. They are looking for candidates who do meet those criteria. And so the results of this case really are to the advantage of the petitioner, because right now the USCIS is receiving, at least in a district level, court pushback looking for very solid and consistent findings. that are well stated, which is always helpful to practitioners as we're preparing legal strategy, because then we know exactly what the criteria is. So I just wanted to add that little bit. And if Alex, if you want to wrap up, we can go move to questions.
Yeah, I mean, that concludes most of what I have. I'm very excited to see what's in store for this case and whether it's appealed or USCIS changes their framework. As Chelsea said, currently the evaluation remains the same, but with a shift more towards focusing on meeting those criteria. And with that, I am ready for some questions.
All right, thank you, Ms. Chelsea and Alexandria, for that insightful presentation. We'll now take a brief break of exactly 1 minute and 11 seconds. Please stay tuned as the sessions will resume shortly.
Are you an extraordinary individual looking to take your talents to the land of opportunities? Welcome to Raju Law, your trusted partner in the pursuit of the American dream. The EB-1 category is designed for individuals with extraordinary ability in sciences, education, arts, business, athletics, or any professions, as well as for outstanding professors, researchers, and multinational executives or managers. This includes individuals with a record of sustained national or international acclaim, and those who have achieved significant achievements in their field. At Raju Law, we specialize in guiding extraordinary individuals through the complex EB-1 application process with ease and efficiency. We will evaluate your unique qualifications and determine your eligibility to secure this highly sought-after immigration preference. We'll highlight your awards, publications, media recognition, and other evidence to establish your extraordinary ability or outstanding researcher status. Contact us today to learn more about how we can assist you in securing your green card through the EB-1 program.
Welcome back, everyone. That was very informative session on the EB category and the recent case developments that should impact petitions. Ms. Chelsea and Alexandria, we have compiled a list of frequently asked questions that many people have about today's topic. We will start with those, and then we will also take a few questions from our live audience as they come in. All right. My first question is: I have met 5 EB-1A criteria, but still received a denial. Could the final merits
Adjudication.
determination have been the cause?
Yeah, I'll jump in on this one. Yes, if USCIS applied the subjective judgment during the final evaluation, despite meeting the criteria, this case ruling suggests that the denial may be legally challenged based on the improper application of the final merits determination. So simply put, yes, you should be able to challenge if the final merits determination was the cause for denial.
All right, thank you, Alex. My second question is, how does the EB-1A petition demonstrate extraordinary ability beyond just meeting the regulatory criteria?
Yeah, this is an excellent question. The extraordinary ability criteria is most effectively demonstrated not only by meeting 3 of the 10 USCIS criteria, but also if you can provide comprehensive, solid evidence-based documentation in forms of evidence that gets submitted with the petition to show a consistent recognition and impact within your field. We're wanting to also ensure that the petitioner's contributions would be of national or international significance. That is really putting emphasis on the national and international significance when you are determining which evidence may be best leveraged for your case. Different from the EB2, the EB1 does really want to see that especially international significance where possible. That way it can meet that heightened threshold of extraordinary ability.
All right. Thank you, Miss Chelsea. I got one question from the audience. Should I take that one?
Sure.
All right. I got a question from Dr. Panchal. Yes, hi, I am PhD in biotech MBA in more than 15 years of experience in research admin as associate professor and having WES assessment, 4 book published, some research paper citations, having award, already work on projects on J1 visa on research projects in 2008, 2014 in UHD.
Yeah. So I think in this case, one of the best tools that you can do is go to our website and put your information into our free evaluation. I still have several questions based on this statement provided, but it does seem like that it's possible that you have an EB-1A match. But in order to determine that, I think one of the greatest resources is going to be our website, rajulaw.com. We have free EB-1A evaluations where you can input this information and we give you feedback on strengths and weaknesses, alignment to this specific visa. So I think that would be the best way to answer this because I do still have several questions based off of what is provided.
Thank you, Miss Chelsea. I think Dr. Panchal got your answer. Thank you for that. All right, I'm going back to FAQ questions again. My third question is, I have strong publications but no awards. Can that help?
Yeah, strong publications and no awards. What we'll want to see there is we want to see high impact publications with a strong citation record. We'll want to note your original contributions to these publications, which can strongly support the EB-1A criteria, both through the publications criteria and the impact to the field. So simply put, the strong publications can satisfy multiple criteria, regardless of whether you have awards.
All right, thank you, Miss Alex. My next question is, if I judge international panels or peer review, does that count?
So if you have strong if you judge international panels or peer reviewing, does that count? The answer that I have is yes. Generally, that does count. Judging or serving as a peer reviewer is one of the USCIS recognized criteria to show the recognition for extraordinary ability within your field. It is more probative if you show that you received an invitation from a higher ranking journal. It is more probative if you are a repeat adjudicator. It is more probative if you have compelling what's the word I'm looking for? Compelling membership that goes along with that to show that you are in a more sought after or higher earning ranking, right, within your field. So all that kind of goes into play, like how you can lean two criteria against each other to really strengthen each other. And that's kind of what I'm alluding to with this response. Yes, it does count. Yes, but it's more probative if you have higher impact factor journals, if you're a repeat adjudicator, if you are invited. Those kinds of things make that more probative and compelling. If you are peer reviewing international journals, that's another great avenue to show international impact. Just throwing that out there as another opportunity. So when you are strategizing where you engage with these journals, that is something that the USCIS will also consider as well. Thank you.
Thank you, Ms. Chelsea. That was wonderful. All right, I'm going to my next questions, which is, my professional memberships are minor. Do they count?
So this one, it kind of depends. What you want to see for EB-1A criteria is memberships that require outstanding achievements for admission. These ones can count towards EB-1A. So if the organization must require exceptional achievements, and the eligibility for these memberships should be judged by nationally or internationally recognized experts. Simply paying for memberships or going online and clicking and just joining for free is likely going to be insufficient. We'll want to see this exceptional requirement to be a part of this organization.
All right. Thank you, Alex. My next question is, do I need a U.S. employer or job offer for EB-1A?
I really like this question because it's something that it's kind of fundamental for this visa requirement is that you do not have to have a employer sponsor you. It allows for self-petitioning and that you can file without that employment sponsor. But I love this question because it's a great reminder of the autonomy that you get with EB-1A. It serves as a great tool for those who are transitioning maybe from H-1B, J-1 visas. You could do some of the other navigational visas that move you from temporary presence to a long-term presence. So love this for applicants who are looking for autonomous movement through the visa application process. So great reminder, great question. It's definitely worth reminding folks that that is an independent self-petitioning visa. Self-petitioning doesn't mean that you can't use an attorney. That means that you can file it yourself, essentially, without that employment sponsor. Thank you.
Thank you, Ms. Chelsea and Alexandria, for explaining these important EB-1A topics so clearly. I'm sure our audience finds this guidance extremely helpful. Before we wrap up, do you have any final advice for lawful permanent residents who are planning to apply for U.S. citizenships, especially regarding preparation and timing?
I think my biggest source of advice right now is strategy matters. Preparation and plenty of time to create a thoughtful and well-supported petition is very important in today's landscape. That goes for EB-1, it goes for EB-2, it goes for any of the visa categories you may be thinking of. Visa preparation is extremely important in this landscape. Having quality evidence prepared is great. So even if you don't think you quite meet the EB-1A criteria today, it's great to meet and kind of strategize for what you would need in the future so that you can make the next thoughtful steps in your career advancement, your research advancement, to position yourself for that petition one day down the road. I have dropped our link to the free evaluation in the chat. It looks like we also dropped a YouTube video to show people how to do that maybe. I see one additional question came in, and it's similar to the last or do I need?
Sorry, should I?
This is an EB-2 question, and this goes back to Mr. Mahajan's separate posting that he's made this week where he's talking about how you can concurrently file for the next month because the bulletin is currently caught up. There's some limited criteria for how you can file concurrently. I would encourage this person to reach out to us. This is a separate question from today's topic, but it is relevant to the current landscape. If we can put our slides up one last time, here's our information. Please reach out to us. We would be happy to help you navigate these questions on specific issues or case-specific information you have. It's really best to work one-on-one because there's so many factors going on right now. But yes, we dropped the link to our evaluation in the chat. Thank you for being here. I will defer to Alex for any closing remarks she has about answering your question about advice for the landscape today.
Thank you everyone for joining us. As we've linked, we have an evaluation for EB-1A. We also do national interest waiver petitions. I know someone mentioned that. We have evaluations for that as well. A lot of the times you'll find they're not the same categories, but there's similar principles underlying both. So feel free to fill out either evaluation, whether you're ready to file or you're looking for gaps in your application that you would like to fill before you file. We can help you navigate those challenges as well to make sure you are fully prepared. And for my final remarks, I will say preparation is the best thing you can do right now for a successful petition, and we can work with you along the way if you choose that route. Thank you.
All right. Thank you both so much for joining us today and sharing your valuable insights. It's always a pleasure having you with us.
Yeah, thank you for having us.
Thank you. All right, so that brings us the final segment of today's session, our weekly immigration news update. Thank you to everyone who stayed with us till the end. Before we close, let's take a quick look at the most important immigration updates from this week that you should be aware of. Until next time, this is Ms. Dushari Turin signing off. Stay informed, stay ahead. Have a great day.
Hi everyone, welcome to this week's immigration update from Raju Law. We bring you the latest news, USCIS updates, and policy changes that matter. This week's top stories include: Trump highlights border enforcement in State of the Union, U.S. to provide consular services in West Bank settlements, new DOL wage rule for H-1B and perm advances, DHS proposes new rules for asylum applicant work permits. Let's start with the State of the Union address. President Trump emphasized border security and removals of undocumented immigrants, saying crossings have dropped sharply and recent releases into the United States have stopped. CBP data confirms a notable decline in southern border encounters. Trump also highlighted drug interdiction efforts, though experts say seizures do not reflect the full volume of drugs entering the country. Next, a significant diplomatic development. The U.S. Embassy will begin offering passport services in Efrat, with similar pop-ups planned in Beitar Illit. The embassy says policy remains unchanged, but Israeli and Palestinian leaders called the move significant. Right-wing Israeli groups praised it, while critics said it signals support for settlements viewed as illegal under international law. Now, a regulatory update from the Department of Labor. A DOL proposal to revise wage rules for H-1B and perm has passed OMB review. Details are not yet public, but the rule could raise prevailing wage levels for H-1B workers and employment-based green card applicants. It must still go through public comments and final rulemaking, a process that may take months. Finally, an important update for asylum applicants. DHS released a proposed rule that would stop accepting EAD applications during periods when processing averages exceed 180 days. The waiting period to apply would increase to 365 days. New processing time rules and eligibility standards would also be introduced. Public comments are open until April 24th, 2026. That wraps up this week's immigration updates. Stay connected with Raju Law for more news, insights, and guidance. See you next week with the latest developments in U.S. immigration.